Physical evidence often goes through many hands from the time it's discovered to the time it's presented at trial. This is called a chain of custody. Each person who has possession of the evidence forms a link in the chain. The authenticity of such evidence is established through testimony of the links in the chain. But what happens if one link doesn't testify? Does that automatically make the evidence inadmissible? The Fourth Circuit addressed this issue in United States v. Howard Arias. A commercial fishing boat called the Don Frank became disabled near the Virginia coast, and an Italian ship rescued the crew. When the United States Coast Guard arrived, one of the officers boarded the Don Frank and found a large amount of marijuana. The Coast Guard then began towing the Don Frank to shore, but it sank. However, the Coast Guard was still able to retrieve about 240 marijuana bales from the sunken boat. Upon arrival at the port, the Coast Guard transferred the marijuana to an agent from the Drug Enforcement Agency, or DEA. The United States government indicted Edmundo Howard Arias, one of the Don Frank crew members, for possession of marijuana with intent to import and distribute while on a vessel subject to United States jurisdiction. At trial, the prosecution introduced the marijuana bales into evidence with testimonies from the Coast Guard officer who retrieved the marijuana from the Don Frank, the Coast Guard officer who received the marijuana from the retrieving officer, the evidence custodian at the DEA facility in Norfolk, and the DEA chemist. However, the DEA agent who received the marijuana from the Coast Guard at the port and transported it to the evidence custodian at the Norfolk DEA facility did not testify. Howard Arias argued that the marijuana was inadmissible because of the missing link in the chain of custody. Nevertheless, the judge found that the prosecution's witnesses provided sufficient testimony to authenticate the marijuana and admitted it into evidence. Ultimately, the jury convicted Howard Arias and he appealed to the Fourth Circuit.